Hi everyone, welcome to our unit on employment law. We're going to cover two big topics in employment law. In this PowerPoint, we're going to cover the law of employment in general, and we're going to talk about wrongful discharge and wrongful discharge lawsuits. We're going to talk about the both federal and state Medical Leave Act, the Family Medical Leave Act. And lastly, we're going to mention a little bit about our employers' rights to control our behavior outside of work, like what we do on the weekends. The next topic we're going to cover in employment law has to do with the laws pertaining to employment discrimination, but that's on a separate PowerPoint. In this one, we're going to talk about the rights of employment in general. So before we get this started, I actually just have a question for all of you, and you can pause the video and think about it. And the question for you is, have you ever quit a job? I bet some of you have. And I would also like to ask you, as a follow-up question, how you felt when you quit that job. You probably felt empowered. A lot of us feel really good when we leave a job that we didn't like, or maybe we move to a new city or want to try something different or return to school. But most of us, when we quit a job, we usually feel pretty good about it, like we're leaving something behind and moving on to something better or different or moving to a new location. And that's pretty exciting. Well, that power that you have to quit your job is actually tied to a really important principle of employment law. So that's where we're going to start. We're going to start with something called employment at will. Employment at will is the rule that we have in the United States that says that an employer can fire you or fire an employee for any reason at any time for any reason. And that's true. That's our default rule. And so that means, can an employer fire you for showing up to work late? Yeah. What if you show up to work late even just one time? Could you be fired for that? Yes, you could. Might not be nice, but you could be fired for showing up to work late. Could you be fired for being rude in the workplace according to your employer? Of course you can. So our employers have the right to get rid of us whenever they want for any reason. But the flip side is the power that belongs to us as employees, which is if we're in a job situation that we don't want to be in anymore, or we're ready to move on to something bigger and better, we also have the power to quit. No one can keep us there. So the idea of employment at will is a reciprocal relationship. You might be sitting here wondering, my employer can't fire me for any reason. What if they want to fire me because I'm a woman and they're being sexist and they only want to hire men? Well, that's not legal. So that's true. So we would call all of those employment discrimination laws, which we'll cover in the next PowerPoint, those are all exceptions to employment at will. Employment at will is the default rule. So when we talk about being a member of a union and making it difficult to fire you, or having a contract that says that you can't be fired except for certain, maybe after a certain number of warnings, that is an exception to employment at will. And so are all the discrimination statutes. Those are all reasons you can't fire somebody. But otherwise, we have that power. Again, you might be thinking this doesn't sound true, but think about it from an employer's perspective. If you're running a business and you have 20 employees, you should have the right to hire the people that you really want to work with, that you think do a good job, that show up with a good attitude and get the job done. And you would want the authority, the power to let go or fire those employees that were not performing, except for reasons pertaining to discrimination, of course. But let's say you just don't get along with somebody. That's okay. That makes it our right to fire that person just because you might have a different personality than them. That's the concept of employment at will. Now, of course, there's other exceptions to employment at will. So I'm going to go through a couple of them in this PowerPoint. So keep the discrimination ones aside. We're going to come back to those. Another exception that I just alluded to is if you have a contract in place. So you might ask yourselves, we just finished our unit on contracts, you might ask yourself, if in your current employment, do you have a contract? Because if you have a contract, and by the way, sometimes they're called employee handbooks, there might be a provision in that contract that overrules the employment at will. And it might give you some protections as an employee. It might say, for example, that you can only be fired after a warning or 2 warnings or after a probationary period. If you have those kinds of protections written into an employment contract or an employee handbook, that gives you additional protections over and above this employment at will default rule. But as we've already learned in our contracts unit, You don't need to have your employment contract written down unless it's for a period of over 1 year, and then it's covered by the statute of frauds. But any other services contract, which employment is not governed by the statute of frauds, does not need to be written down, and would also be governed by this concept of employment at will, meaning you could be fired for any reason at any time. All right, what's another exception? Well, we have a body of law that we refer to as wrongful discharge or wrongful termination. And that's a fancy way of saying you were fired for a bad reason. Now, again, what would be a good reason for firing somebody? Showing up to work late, not being a team player, not getting the job done. We would all accept these as good reasons to terminate somebody. But what would be a reason of wrongful discharge? Wrongful discharge is a type of lawsuit that a fired employee brings against her employer if she feels that she's been fired for a reason that violates public policy, a really bad reason. So again, it would be me suing Middlesex Community College after I got fired if I felt that the reason I was fired was for a bad public policy reason. So let's go through a few of these examples. They're all covered in your book also, but I want to highlight them. Wrongful discharge example number 1 would go like this. And this is based on a true story that's highlighted in your book. A nurse was working at a hospital alongside a doctor. The doctor got sued for medical malpractice. A patient alleged that the doctor committed the tort of medical malpractice. And the nurse was going to testify at the trial against the doctor and say, yeah, that doctor, didn't do what he was supposed to do. Well, guess what the doctor did? The doctor did. He went to the nurse and he threatened her and said, you need to lie for me under oath at the trial. Otherwise, I'm going to fire you or I'm going to get you fired. So what was he doing as her boss? He was forcing her or threatening her to commit perjury, which is a crime, in order to save her job. So let's say she quits in protest, or he does fire her if she refuses to testify as he wants her to. She could then sue the hospital or the doctor, and the name of her lawsuit would be called wrongful discharge or wrongful termination, because the reason that she was fired is because she refused to violate the law. So we can see why that would be a good reason to sue the employer, or another way of saying that is that's a really bad reason to sue somebody. We don't accept that. That's not saying she was late to work or she wasn't good at her job. She was being threatened to commit perjury. That's a bad reason to fire someone. So this is a basis for wrongful discharge. A second example of wrongful discharge could be seen by firing an employee for exercising their legal rights. Again, another example that I took straight from your book, but it really highlights this type of lawsuit, would be an employee who got injured at the job. If you're injured on the job, like you slip and fall, you get hurt by a forklift, you have the legal right to bring a workman's compensation claim against your employer. We're not separately covering that in this class, but you can certainly look it up. It's like a tort type lawsuit, but it's employee versus employer. And you have the right, employees have the right to bring workers' compensation claims. An employer cannot fire an employee because they filed a workers' compensation claim. That would be unlawful and would also be the basis of wrongful discharge. I hope you can kind of see where we're going with this theme of reasons that violate public policy, reasons that offend us to our core. Here's another one that's actually a little bit trickier. And this is, I actually, funny enough, remember learning about this case when I was in law school eons ago. We actually learned about this case, the armored truck example. That's why I put a picture of that one. So if you've ever seen an armored truck, here's a picture of one. And if you're familiar with armored trucks, there's always two people working in the truck. There's a driver and there's someone with the driver. And the reason is one person always has to stay with the truck while the other one goes into the bank or into the business in order to get the money and bring it out. That's the rule. And it's an important rule for the armored truck companies. Well, a true story is that the armored truck drove up to the bank, and one went into the bank and the other the other employee stayed with the car as he's supposed to. Well, it turns out that the one that went into the bank happened to have gone into the bank in the midst of a burglary, a holdup at the bank, and ended up helping to save someone's life in the course of this robbery. There was an armed gunman, and I believe the other truck driver tackled him, the armored truck guy, he tackled him to the ground, and he saved someone's life. And I'm sorry, so I'm saying this wrong. I'm not going to redo the whole video, but one guy goes into the bank, the other one who's with the truck, he leaves the truck, and then he goes and he helps to end the robbery from happening. Well, he left the truck, so you can imagine what happened. He got fired. He got fired from his job for leaving the truck. So what happened? Well, he filed a wrongful termination lawsuit against the armored truck company for terminating him, saying, wait a second, I saved someone's life. I did a good thing. That's wrongful termination to fire me for literally saving someone's life and stopping this robbery. But the company did have the right to fire him. That one, the courts have said, could have really gone either way. So another example of wrongful termination. There's also another great example in your book having to do with medical marijuana, this Roe versus Teletech case. So take a look at that one and just note, look at the cases from 2011. So we've come a long way in the last, decade plus, just in terms of medical marijuana law, but take a look at this earlier one. It's really quite fascinating about how that plays out with wrongful discharge. All right, I have a couple more topics to discuss, but I'm actually going to pause this video here and finish them on the next video.